A primer on pupil non-discrimination and civil rights compliance. This presentation has been prepared by the staff of the Office of Legal Services in the Wisconsin Department of Public Instruction in order to give school district staff and other parties an overview of the state law regarding pupil non-discrimination and some of the similar federal laws governing civil rights compliance. Slide 2, State Statutes. Wisconsin Statute 118.13 sub 1 was promulgated in 1985 and provides that no person may be denied admission to any public school or be denied participation in or denied the benefits of any curricular or extracurricular program because of their sex, race, religion, national origin, ancestry, creed, pregnancy, marital or parental status, sexual orientation, or disability. Sex discrimination includes allegations relating to sexual assault and sexual harassment. Disability discrimination includes discrimination on the basis of emotional disabilities, physical disabilities, mental disabilities, or learning disabilities. Slide 3, State Statutes. Subsection 2 of Statute 118.13 provides that school boards must develop written policies and procedures to address non-discrimination complaints and also empowers the state superintendent to hear appeals of negative determinations of such complaints. Subsection 3 of the statute also provides that the state superintendent may promulgate rules necessary to implement and administer the pupil non-discrimination statutes. Be aware that the statutes and rules generally refer to the state superintendent, but DPI and state superintendent will be used interchangeably throughout this presentation. Similarly, these statutes and rules generally refer to these obligations being those of the school board, but district and board will be used interchangeably. Slide 4, DPI's Pupil Non-Discrimination Program. DPI's Pupil Non-Discrimination Program provides technical assistance to local school districts, parents, and school district residents on matters relating to non-discrimination and equality of educational opportunity under state law and related federal laws. The program also includes the appeal process provided for in state law. Within DPI, these duties are divided between a staff consultant that provides technical assistance and the Office of Legal Services, which handles appeals of school district decisions. Slide 5, Administrative Rules Generally. Chapter PI 9 of the Wisconsin Administrative Code, which became effective in 1987, contains the rules implemented by DPI to administer the pupil non-discrimination statutes. PI Section 9.03 provides specific areas which must be included in the non-discrimination policies adopted by districts. For example, how admissions to classes and programs will be handled, and prohibiting discrimination in instructional and media materials. We will get into further discussion of it later, but DPI is aware that many districts have adopted model policies for discrimination, bullying, and other topics drafted by a service that provides such model policies to school districts. DPI may refer to those model policies throughout this presentation, but obviously, each district is free to adopt any policy it desires as long as it complies with the requirements of statute and rule. Slide 6, Complaints. PI Section 9.04 outlines specific criteria for how districts must handle non-discrimination complaints, including an employee must be designated to receive complaints, usually known in policies as the compliance officer. Complaints must be acknowledged in writing within 45 days of receipt. A determination must be made on the complaint within 90 days of receipt. And complainants must be notified of their right to appeal a negative determination to DPI. Slide 7, Reporting. PI 9 also requires that each district submit to DPI an annual report about any discrimination complaints it has received. DPI collects this report electronically through WISE Secure. DPI prepares and sends a memo and worksheet with instructions to districts to help them prepare for final submission of the information electronically. Slides 8 and 9, reporting data. Those reports are due in December for the previous school year. For example, data for the 2022 to 2023 school year is due in December 2023. On these next two slides is information about the number of discrimination and harassment complaints across all districts reported for the 2021 to 2022 school year. Comparing this data to previous years, a significant increase in reported complaints is reflected, and significant increases in the numbers of complaints of discrimination on the basis of sex, race, and sexual orientation are seen. Slide 10, 5-year evaluation. PI 9 further requires districts to evaluate the status of non-discrimination and equality of educational opportunity in the school district at least once every 5 years on a schedule set by DPI. A self-evaluation occurred during the 22-23 school year. Districts must provide opportunities for participation in the evaluation by pupils, parents, and residents. Slide 11, Appeals. PI Section 9.08 provides the parameters for appeals of non-discrimination decisions to DPI. The appeals must be made from a negative determination of a board and within 30 days of the decision. Slide 12, Overview of Appeal Process. The bulk of the remainder of the presentation will be focused on discrimination appeals. So let's start with a very high-level overview of what functionally happens after an appeal is received by DPI. First, the Office of Legal Services reviews the submitted appeal and takes one of 3 actions: refers back to the district, dismisses the appeal, or sends an acknowledgement letter to the parties and asks the district to send its record to DPI. Then, after the district sends its record to DPI, DPI usually sets a schedule for any additional written submissions the parties wish to submit. Slide 13, Overview of Appeal Process continued. After the written submissions are filed, the Office of Legal Services reviews the submissions and drafts a decision and order. There are no statutory deadlines imposed on these appeals. DPI strives to complete opinions no later than 2 months after receipt of the final written submission. However, depending on workloads and other factors, it may be longer. When the decision and order is issued, depending on the findings, there may be the conclusion of the appeal or a corrective action plan may be ordered. In cases involving corrective action plans, DPI continues to monitor the district's progress until the plan is completed. Slide 14, Appeals 2013 to 2022, broken down by year. Before we dig into the details on appeals, here is some data regarding the number of appeals that DPI has processed in the last 10 years. You can see that there have been 46 total appeals in those years. So thinking back to the reporting data from the 2021 to 2022 school year, of the 3,000 plus total complaints made across the state, less than 20 were appealed to DPI. Slide 15, Appeals 2013 to 2022, broken down by protected class. This data breaks down those 46 appeals by the protected class involved. The largest number of appeals involve race, then disability, and sex. Slide 16, Overview of Appeal Process. Let's go back to that first step in the appeal process and get more specific. Remember, there were 3 possible avenues after receipt of an appeal: referral back to the district, dismissal, or acceptance of the appeal and further processing. Slide 17, Initial Review. There are several reasons why an appeal to DPI may be referred back to the district. First, DPI can only hear appeals, so if the complainant has not already filed their complaint with the district, DPI will send it to the district with direction to process it pursuant to the relevant discrimination policies. Second, a complainant may try to appeal something that is not a final decision of the district, or request that DPI intervene before the district has completed its investigation of the underlying complaint. Again, DPI's authority applies only to appeals, and so requests of this nature will be sent to the district for further handling. Third, DPI is seeing an uptick in appeals from complainants that were not processed as discrimination complaints at the district level. For example, complaints that were handled by the district pursuant to its bullying policy. Districts should carefully parse underlying complaints to determine if allegations involve a protected class and constitute allegations of harassment or discrimination that must be specifically resolved pursuant to its PI-9 discrimination policy. Districts should be aware that the model bullying policy usually provides for investigation by building staff, such as a principal. However, that policy also requires referral to the district compliance officer if the staff investigation reveals the bullying may have been based on a protected class. Finally, an appeal may also be dismissed for a lack of jurisdiction. This includes appeals that are filed more than 30 days after the district's final determination. Most often, a dismissal for lack of jurisdiction is because the allegations are related to implementations of IEPs or violations of the IDEA. Those issues are to be resolved pursuant to Chapter 115 of the Wisconsin statutes, but parents often seek to allege general discrimination based on disability. Slide 18, Overview of Appeal Process. On to the second step. If DPI accepts an appeal, it will acknowledge the appeal to both parties and ask the district to file its record. After the record is received, DPI will set a schedule for the parties to offer written submissions in support of or opposition to the appeal. The timing for these submissions may vary due to the issues involved. Slide 19, the underlying record. The district's record of the underlying complaint includes records related to the complaint, including investigative notes and reports authored by the investigator, copies of any and all of the district's pupil non-discrimination policies and complaint procedures in effect during the relevant school years, and any and all other documents related to the complaint or the allegations which were considered by the investigator. It's important for districts to understand that DPI is not a fact finder on discrimination appeals and does not develop independent evidence. DPI's determination is almost always confined to the record developed by the district. Therefore, it is in the district's best interest to maintain consistent records and perform thorough investigations. If DPI cannot find the evidence to support the district's determination in the record presented, it will most likely make a finding that the determination was incorrect or order a new investigation. Slide 20, Overview of Appeal Process. The third step is DPI's review of the record and any written submissions of the parties in order to draft a decision and order. Slide 21, OCR guidance. You may be wondering how DPI arrives at its decisions in discrimination appeals. Well, there is almost no Wisconsin case law interpreting Section 118.13, and there is no directive in the statute itself on a standard of review. So DPI relies on guidance from the U.S. Department of Education, Office of Civil Rights, relating to allegations of discrimination under federal law. These guidance documents are published in the Federal Register and often cited in DPI's decisions. OCR resolution documents, which provide insight into what proper investigations and responses to discrimination may look like, are also available online and can be searched by protected class, year, and other criteria. That page is linked in this slide. Slide 22, Overview of Appeal Process. DPI will issue its determination in the form of a written decision. There are a number of different possible outcomes for appeals that DPI reviews on the merits. Slide 23, Appeals, Possible Outcomes. The appeal may be denied or dismissed. This means that DPI agrees that the district's determination on the underlying complaint was correct. The appeal may be granted. This means that DPI thinks that the district's determination on the underlying complaint was incorrect. The appeal may also be granted in part and denied in part. This may occur in cases where there are multiple issues or in situations where DPI agrees that the district's ultimate determination is correct, but the district failed to follow its policies and procedures. Slide 24, Appeals 2013 to 2022, broken down by resolution. Here is a breakdown of those 46 appeals processed by DPI in the last 10 years by how they were resolved. You can see the majority of appeals were dismissed. That includes dismissals for lack of jurisdiction and dismissals on the merits. Slide 25, Corrective Action Plans. If DPI grants an appeal, either on the merits or because of a district's failure to follow its policies, the rule provides that DPI shall issue an order to comply, which includes a requirement that the board submit a corrective action plan within 30 days of the order. DPI has limited ability to provide remedies to impacted complainants, so the focus in corrective action plans is on systematic change in the districts. Corrective action plans where there is a finding of discrimination may include things like equity audits and other ways to assess how to prevent discrimination in the future. Slide 26, Granted in part, dismissed in part. However, as noted previously, a large number of the appeals that are granted in part is because there was a finding that the district's determination on the merits of the allegations was correct, but that there was a failure to comply with district policies and procedures. Corrective action plans in these cases focus on staff training to ensure compliance with policies in the future. Slide 27, Most Common Issue. The most common issue DPI is seeing with respect to district compliance with policies or procedures is districts adopting the model policy or some other policy, but not being aware of the policy's requirements. This leads to a failure to comply with those requirements when complaints are actually made. Thinking back to the requirements of Section PI 9.04, they are few and brief. If a district adopts a detailed policy like the model policy that goes much further, then it must comply with that adopted policy. Slide 28, District Investigations. PI 9 does not require an exhaustive investigation into a discrimination complaint, or the level of investigation OCR may perform. A district satisfies the provisions of PI 9 simply by performing an investigation reasonably calculated to determine whether the allegations of discrimination in a complaint are true. Slide 29. District investigations continued. However, be aware that the model policy requires a number of steps that districts might overlook. Non-model policies may require other steps. These requirements include mandatory investigation steps like investigations conducted by the named compliance officer and interviews with the complainant, respondent, and all named witnesses. There are also mandatory triggers in the model policy which require any district employee, and even board members, to report discrimination allegations to the compliance officer, and which require processing of complaints from those a district might not commonly think are covered by the policy, like community members. Finally, there are mandatory outcomes in the model policy, which require a written report and certain appeal rights within the district itself. Slide 30. District investigations continued. If a detailed policy is adopted that requires rigorous, comprehensive, and broad investigations in response to articulated complaints or other triggers, DPI will require adherence to those policies. This is true even if a non-compliant investigation would meet the DPI's reasonably calculated standard. DPI will hold districts to the policies that they adopt. Slide 31. Examples. Let's talk about specific examples from past appeals. DPI has held that in response to allegations of a hostile environment, it was reasonable for a district to only interview the complainants, named witnesses, and respondents. A district is not required to conduct focus groups or interview other current students not named to determine whether they suffered discrimination. Essentially, districts are required to explore the allegations made in the complaint, but not required to go on a fishing expedition looking for other allegations. Slide 32. Examples continued. DPI has also held that it was reasonable for an investigator to rely on interviews of staff with first-hand knowledge of the relationship between students in finding that a classmate's behavior was not motivated by a student's disability, rather than rely on the parent's assertions that the student was targeted based on disability without further factual support. Conversely, DPI has held that it was not reasonable for an investigator to rely solely on a school resource officer's second-hand statement that classmates who bullied a student were not motivated by the student's disability, without the investigator independently developing their own evidence regarding the classmates' motivations. The key difference here is that the investigator in the first case interviewed the staff and then weighed the staff opinions against other evidence. In the second case, the investigator solely relied on the second-hand statement without developing any other evidence to support this finding. Slide 33. Examples continued. Here are some other examples of appeals that were granted, at least in part because districts failed to comply with their discrimination policies. DPI ordered a district to do staff training when a parent made complaints to several different staff members that a physical attack on her disabled son was a hate crime. There is no doubt that this is a claim of discrimination that should have been recognized by staff. Per the model policy, they were obligated to report it to the district compliance officer immediately. At one point, the superintendent even acknowledged the parent was making a discrimination complaint, but directed her to formalize it. Again, the model policy puts the onus on district staff to recognize and send complaints to the compliance officer. There are no magic words or actions required by the model policy for complainants. The obligation falls to district staff to ensure claims of discrimination are processed appropriately. Slide 34, DPI recommendations. Let's sum up this section on policies with some recommendations from DPI. First, districts should review their discrimination policies with an eye towards ensuring that the policies can be practically applied to discrimination complaints that might be received. Complaints must be responded to in a timely manner and with a sufficient response. Does your policy allow for that, or is it overly complicated? Second, your staff needs to be trained to recognize discrimination complaints and understand when the discrimination policy applies to communications or complaints they receive. Staff also need to understand their personal obligations under the policy. The model policy requires each and every staff member to diligently report. Finally, complaints need to be considered carefully to determine whether they should be processed pursuant to discrimination policies. If there is any indication that bullying is happening because of a student's protected class, that complaint should be handled pursuant to the discrimination policy, not the bullying policy. The model bullying policy also requires referral to the compliance officer in these cases. Slide 35, Forms of Discrimination. It's helpful when processing complaints to understand the different forms of discrimination that might be alleged and how DPI might review decisions related to these different forms on appeal. Most allegations are those one-time acts that everyone generally understands to be discrimination. Things like a physical attack by a fellow student based on a student's disability or other protected class, or an allegation involving verbal taunts based on a student's sexual orientation. There is no unique standard applied to these cases. As noted previously, DPI reviews to ensure the district's determination is based on an investigation reasonably calculated to determine whether the allegations of discrimination in a complaint are true. There can also be allegations of differential treatment, like a school disciplining a Black student more harshly than their white peers. We'll get into detail on how DPI analyzes appeals related to these allegations in a moment. There can also be allegations related to an ongoing hostile environment, such as a student being regularly subjected to racial slurs or continuing mistreatment based on their gender identity. There is a unique standard to be aware of for these types of allegations, which we will discuss further in a few slides. Slide 36, Differential Treatment Analysis. Let's talk about discrimination allegations related to differential treatment. This type of discrimination occurs when district employees, acting within the scope of their duties, treat students differently on the basis of their protected class without a legitimate, non-discriminatory reason. Per the OCR guidance discussed previously, if a student has been treated differently than other similarly situated students, the district must be able to show legitimate, non-discriminatory reasons for the treatment. These reasons cannot be a mere pretext for discrimination. On appeal, DPI will apply this standard to determine if the district's reasons were legitimate, non-discriminatory reasons. Slide 37, Differential Treatment Example. In one recent appeal, DPI held that a district did not have a legitimate, non-discriminatory reason for disciplining a Black student more severely than a similarly situated white student based on the following facts. The Black student brought an unloaded BB gun to school for show and tell, played with it on the playground, and it was eventually confiscated by staff when discovered. The Black student received a 1-day suspension. However, earlier that same school year, a white student at the same school had brought a knife to school, showed it off to friends on the bus, and it was confiscated by staff when the student arrived at school and it was reported they had a knife in their backpack. The white student had only served detention for the offense. DPI held that there was no legitimate, non-discriminatory reason for the differential treatment between these two students. It's worth noting here as well that these types of allegations highlight the importance of developing a sufficient record during the discrimination investigation. DPI often receives records from districts which do not reflect the races of students involved. It's impossible to determine whether there is differential treatment based on race without such evidence. Slide 38, hostile environments. Discrimination as a result of a hostile environment occurs when a district fails to adequately redress a hostile environment, such as a racially hostile or sexually hostile environment. It is not enough that a hostile environment exists in a district to establish a finding of discrimination. There should be a finding of discrimination when all of the following factors are present. A hostile environment exists, and the district has actual or constructive notice of the hostile environment, and the district fails to adequately redress the hostile environment. Let's take each of these elements in turn. Slide 39. A hostile environment. Does it exist? Per OCR guidance and case law, a hostile environment exists where harassment based on a protected class is severe, pervasive, or persistent. There are numerous factors to generally consider when determining whether such an environment exists, including the context, nature, scope, frequency, and duration of incidents, and the identity, number, and relationships of persons involved. It's important to note that acts need not be targeted at the particular complainant in order to create a hostile environment. So, for example, if racial slurs are regularly being directed at one particular student, a hostile environment is being created for all students that are hearing them, not just the student that is the target of the slurs. Slide 40, hostile environment, example. DPI has found a racially hostile environment existed in a district on the basis of 19 documented incidents of racial harassment by students across a number of different schools over a 4-year period, including numerous uses of racial slurs. Slide 41, hostile environment. Did district know? Again, a finding of discrimination requires actual or constructive knowledge on the part of the district. In the example case noted previously, DPI found the district had actual notice of the racially hostile environment based on its own discipline records documenting the 19 instances of racial harassment. Also, there was constructive notice because the complainant in that matter had been raising concerns to district staff about racial harassment for some time. Most of these reports of alleged discrimination or harassment should have triggered investigations on the part of the district pursuant to their policies. Slide 42, hostile environment. Did district adequately respond? OCR guidance provides that once a district has notice of a hostile environment, it must take reasonable steps to eliminate it. Specifically, the appropriate response to a hostile environment must be tailored by the district to fully redress the specific problems experienced as a result of the harassment and reasonably calculated to prevent recurrence. There are actually many resources published by the OCR available for districts to consult on what may constitute inadequate response, including resolution documents discussing real-life attempts, a 2010 Dear Colleague letter, and a 1999 checklist. Those last two items are linked here in the slides. Slide 43, hostile environment, adequate response. The key points you should take from this presentation on what constitutes an adequate response to a hostile environment is that it cannot simply be addressing specific incidents as they arise and thinking that is enough. An effective response to an environment where harassment is severe, persistent, and pervasive will require large-scale work. This might include training for students and staff, follow-up inquiries to those affected by harassment, prompt responses to additional incidents in the future, curriculum changes to foster respect, and ongoing assessment of the effectiveness of efforts. There is no one-size-fits-all solution, and districts may need to mix and match a number of different actions to respond adequately to a hostile environment. Slide 44, Federal Civil Rights Compliance. The final piece of the presentation today will cover some pieces of federal civil rights compliance in which DPI is involved. This is a very brief overview, but there is more detailed information available on DPI's website and linked here in the slide. The applicable laws include Title VII of the Civil Rights Act of 1964, prohibiting discrimination on the basis of race, color, and national origin, Title IX of the Education Amendments of 1972, prohibiting discrimination on the basis of sex, and Title II of the Americans with Disabilities Act, requiring accessible facilities. You may have previously heard this type of oversight or program referred to as methods of administration. It has traditionally been handled by DPI's Division of Career and Technical Education because the hook is the federal funding associated with vocational education. That funding is dependent on districts complying with federal civil rights laws. Internally within DPI, oversight of this compliance is now transitioning to the Office of Legal Services. Slide 45, Civil Rights Compliance. The goal of this program is not punitive, it is education. DPI wants to help districts identify and remedy civil rights violations. The Office of Civil Rights delegates to DPI the authority to conduct compliance reviews of subrecipients of career and technical education grants. DPI has to formulate the methods of administration plan that will include civil rights compliance reviews of districts and reports biannually to OCR on that work. OCR provides technical assistance to DPI, and DPI provides technical assistance to districts. And though, again, the hook is the career and technical education funding, the goal is broader than eliminating discrimination in that area. The goal is to conduct a broad review of all civil rights laws imposed on districts. DPI wants this process to be worthwhile for districts and provide them insight on the ways in which they can improve. Slide 46, Site Reviews. So, what does this kind of oversight functionally look like, and when might it happen in your district? Let's get into it. Every year, 9 districts are selected to take part in a site review conducted by DPI staff. The selections are made on certain criteria, including data comparing overall enrollment figures for certain subgroups in the district compared with the enrollment in career and technical education programs. This data analysis identifies under or overrepresentation of these subgroups in each career and technical education discipline. Under or overrepresentation is defined as more than a 25% difference between the discipline enrollment and district overall enrollment by each of the subgroups. The districts are then ranked by these percentages, and selections are made based on district size. A certain number of large, medium, and small-size districts are chosen each year. Districts may be considered for elimination from the review requirement on a case-by-case basis, based on factors such as involvement in ongoing litigation related to compliance or participation in an on-site review within the last 6 years. Districts can also request a postponement for 1 year due to extraordinary circumstances such as the death of key personnel or natural catastrophes affecting the district. Slide 47, site reviews. Site reviews have 3 phases: before, during, and after. Before the on-site review, DPI asks the district to gather relevant documents for review. These include the required annual non-discrimination notices that each district must publish. During the site review, DPI interviews staff and students about non-discrimination practices and does an actual physical assessment of the school facility to ensure that the district is in compliance with accessibility requirements. After the site review, DPI develops a report that identifies any findings of noncompliance and required corrective actions the district must take. DPI continues to monitor the district until all corrective actions are completed. Slide 48, common corrective activities. Common corrective activities associated with findings in these reviews are items like updates to notices or policies to include required non-discrimination language, revision of internal procedures to ensure counseling activities are not biased, and facility updates as required by the ADA. Slide 49, Title IX. DPI often gets questions from districts about Title IX, the federal law which prohibits discrimination on the basis of sex in education programs or activities that receive federal financial assistance. However, DPI has no oversight over Title IX or authority to interpret its regulations. That authority lies entirely with OCR. Therefore, DPI defers any questions about Title IX to OCR. There is a link on this slide to further information on OCR's role in enforcing Title IX. Slide 50. Questions? Thank you for doing the important work of watching this presentation in order to learn more about your part in handling pupil non-discrimination and civil rights compliance issues. If you have any questions about what you have seen or need technical assistance, please contact Attorney Carrie Race in the Office of Legal Services at DPI. She can be reached via email at kari.race@dpi.wi.gov.